Well, hello, folks. I'm sorry. Me and Alphonse are just in the background running our mouths, getting ready for the journey we're going to take here. I welcome everybody here. This is gonna We're gonna go down many different avenues as always. So, if you have questions, if you have questions, please let us know, and I'm gonna welcome Alphonse. Thank you for coming again.
What's happening, brother?
Hey man, it's good. It's good. We've got a plethora of updates. I'll start with mine, and then I'm going to let Alphonse give his. So Gary and I have officially filed our summons. I mean, filed our complaints. The summons are in. So now I don't have any issue whatsoever sharing with y'all my complaint. Okay, and why
Brandon,
is
explain. Here's what I want you to do. Explain that process. In other words, how you filed the complaint and how the whole summons process works.
okay?
So from start, like if you're doing it from the start.
So in Louisiana, it was different than Mississippi. In Louisiana, the marshals are no longer serving summons. The sheriff is no longer serving summons in Louisiana. So, guys, this used to be the duty of these agents. Okay, so I actually was able, because I'm not a party to the suit that Gary is pushing. I was able to serve the summons. So I went, serve, did my affidavit that service was done, sent it into the court. Now, mind you, for complete service, they had to have the complaint, the summons page from the clerk, right? That they were being
The clerk created the summons.
Yes.
Okay.
Notice of suit coming in, right? You've got 21 days, right, to answer. Okay. So from the date after service is when the in Louisiana that the count starts. The day of doesn't count; it's the day after. Okay, so for Mississippi, we had to hire a process server, and the reason for that, Mississippi's local rules is that you can't be an out-of-state resident to serve process. You must be an inhabitant of the state of Mississippi. So those are done. And so with that, I'll share the complaints, and I may do that this afternoon. I may not. We'll see how this afternoon goes. 95% of y'all in both the Telegram groups and on YouTube have specific problems. Those specific problems have to do with quasi judicial courts. If I do not get to sharing the complaint today, I promise each and every one of y'all that I will do a separate video where I share it. I'm going to post it in Telegram. If you're not part of the Telegram yet, you should be. A lot of information. We're growing exponentially. You can't learn this stuff overnight. Go ahead, Alphonse.
No, and it's funny how we both ran into the administrative process at the same time. You found it within like a day or so. I'm looking the same thing. I'm reading the same thing. And the way it hit me was I'm just looking at the actions of what these. I'm saying, wait a minute. They're not following any standard legal process here. How are they getting away with this? And I said, I'm looking at Amjur, and it says administrative law. So let me read this. And within the first 3 paragraphs, I understood everything that they were doing. Because what happens is these administrative courts are actually created under the executive branch of government, okay? They're not under the judicial branch. They're under the executive branch of government. And believe it or not, they're given all 3 powers in that under that executive branch. But there's certain powers that they can't impose upon you or I because we have state and federal constitutionally secured rights. They just can't overthrow that. But if you don't object to being in that quasi-judicial administrative court, they will take away trial by jury from you. They will take away due process from you. And guess what? They don't even have to follow the rules of evidence in that court, okay? And they could skirt the Constitution in that court. That court is specifically made for what Brandon and I call inhabitants of the municipality. And what an inhabitant is, it's a member of the corporation. So if you're an employee of that borough or that township, you're an inhabitant, okay? If you have a state license to do business in that state, they can treat your business as an inhabitant of that municipal corporation, okay? That's what those courts are for. Those courts are really set up for agencies working with agencies. Like when I'm fighting the sewer authority, Brandon, I'm looking up on case law, and lo and behold, guess what I see? Aston Township suing the sewer authority. The sewer authority that they created. So they created the sewer authority, and there's like 3 lawsuits up there of them suing each other. But that's all done under that quasi-judicial administrative process. This is not a judicial court where you and I want to be. When we're in a judicial court, you have all your constitutional rights you can invoke. I can invoke trial by jury. I can invoke due process. There's a million things I can invoke in that judicial process that they're going to steamroll me in when I walk into that administrative court process. So that's why we want to. It's not a straw man thing. It's not, anything to do with your birth certificate. They are treating you as one of their, and they're trying to move you under different rules than what you should be moved under. So that's basically my little view on quasi-judicial administrative courts.
Well, before you get too far, and why you said you brought up the straw man deal, and I want to nip this in the bud right now, because I look, it's wonderful how synchronicity works, because you brought it up, and I just want you guys to know I'm going to bring up moot questions or cases of hypothetical issues. This is the American Jurisprudence, May 2022, Section 43 from the court section. Unnecessary decisions by a court are to be avoided. Courts will generally decline to decide moot controversies. A case is moot when the issues presented are no longer live or the parties lack a legally cognizable interest in the outcome. Okay, so let's stop right there. This quantum grammar crap from David Wynn Miller, nobody else on the earth can read his crap. This straw man crap, nobody inside these courts know anything about it. The secret trust, nobody in the courts know anything about it. It is purely hypothetical, and it is an imagination within your own mind. It is what is called an abstract idea. Okay? So in order to push a case through the courts, you have to remember, Caesar's world works on what? It's got to be based in reality. It's got to be concrete. There has to be physical, tangible evidence, not hypotheticals within somebody's mind. A court will also generally refuse to decide a purely hypothetical or abstract question or issue, or one not arising out of the facts involved in the case brought before it. The court lacks discretion to consider the merits of a case over which it is without jurisdiction, and thus, by definition, a jurisdictional ruling may never be made prospective only. And this gets back into that conversation I had with people. All right, your ideas of the world don't necessarily fit into how Caesar's kingdom works. And what I mean by Caesar's kingdom, it's objective only. It's not subjective. Okay, we have our securement of this religious freedom to move forward and think independently of anyone else, and it doesn't have to seem logical to anyone else. That's your protected right. That's a substantive right. But you can't go plead inside a court your fairy tales of hobgoblins in the bushes and all capital letter names over here that have secretly hid you. Nobody can prove it, right? So it's what's called a moot question. So, and here are the case laws down here that protect, that back all this up. And you can go look up David Wynn Miller's lawsuit, and I've posted it on Telegram. And he wasn't even allowed to put any more cases in because nobody could read it. It was so. One judge said this language is so far from the English syntax and grammar that I have no idea what he said. The exact quote from the judge. Okay, so we'll go here. Here's another one. Just remember this one. These are dead ends. Okay, they're just dead ends. Free man on the land philosophy. Hold on, I'll tell you what I got to do right here. I got to turn this down, don't I? How about that? That better? You can hear me still?
Yeah, I can hear you.
Okay, good. I don't hear the echo now. Okay. Persons are not exempt from regulatory statutes on the basis of a claim that they are free men and not 14th Amendment citizens. How? So you're not going to get any relief in a court going and fighting these arbitrary ideas that live only in the confines of your own mind. Okay, so I'm going to go back to the administrative law now and let Alphonse continue on.
Yeah, you still got some. We still got people in the group saying, "Oh, they're connecting your social security number to the straw man they invite to the court." No, stop with that stuff. There's nobody coming into court to say, "I own Mr. Sibley's birth certificate, and I now have control over his account." I'm over. It's never come up in any court case I've ever seen. My paperwork's been used in thousands of cases, different things. I've never heard anyone come back, and I've responded to multiple hundreds of lawyers' documents. Not once did any argument about any security account or trust account. So it's never come up. So get away from it and get away from the people teaching you that crap. It's garbage. Leave it alone. That's not how you win. It's not how you beat these people. You beat them with basic logic and the rules. Hey, here's the rule. Here's what it says. Why aren't you following it? Because if they're not going to follow it, eventually when you move that case up through the chain, there's going to be an adult that sees this, and they're going to know exactly what you're doing. And eventually that person that didn't want to follow that rule earlier is going to have to explain why he didn't follow the rule. And it's going to come back on them. So get away from this, like he said, hobgoblin in the bushes stuff. It's all nonsense. And it frustrates me because I've been doing this for over a year on Telegram now, and I still get these people coming in my group talking about this straw man stuff. Enough.
And look, we'll just go straight to the reality. The taxpayer identification number is a sole proprietorship employee identification number assigned to you by the IRS. Okay. The Department of Treasury sends it out, and it's your employee identification number. That's exactly what the Social Security number is for. And when you rebut the IRS claims and all that crap that goes in the IRS deal, there's nothing they can do about it. That's why it's just a useless, a fruitless endeavor to go down that rabbit hole. Okay, so let's start here. So many of you have issues with administrative quasi-judicial courts. You go in there, you walk in, and they don't follow the rules of evidence. They don't follow the rules of civil procedure. They don't follow anything. There's no discovery. They just railroad through everything. Okay, so let's just read out of American jurisprudence, and then what I'll do is I'll pull up maybe the charter of a city, and listen, if you have the city moving against you, you need to go read their charter. Most likely inside their charter is their rules of evidence. Say for Texas, okay, after 4 months of helping this lady, I finally found the rules of evidence for quasi-judicial courts and how to object to get a jury trial. Right, it's right there, but nobody knew to go look inside the Administrative Procedure Act of Texas. I didn't know that. I didn't know that until I found all this stuff right here. And it's crazy because here, and I'll just do this before we start. All right. So everybody's looking for certain ideas. What's the definition of person? And each of you can go verify this if you want. This is Louisiana Revised Statutes, Chapter 49, 951. This is the codification of the Louisiana Administrative Procedure Act of 1954. Okay. So this regulates all departments of the state who are acting in administrative function. Okay. There's two roles of government. Let's talk about this because this is a huge issue. Governmental functions and proprietary functions. Okay. All right. When it operates in a proprietary function, it is not immune from lawsuit. It is operating for profit. Okay. That's just the simplest form of it, but you need to go look into these things. So in all of Louisiana's code, administrative code, I never found the actual definition of person until I went tearing apart the wildlife and fisheries. And lo and behold, wildlife and fisheries, the first article, power and authority, it was pulled from the Louisiana Administrative Procedure Act. I was like, well, hold up. I've never seen that before. Let's go look this up. And here we are, the first chapter of it, the definitions. Person means any individual, partnership, corporation, association, governmental subdivision, or public or private organization of any character other than an agency, except that an agency is a person for the purpose of appealing an administrative ruling in a disciplinary action brought pursuant to Title 37 of the Louisiana Revised Statutes of 1950, prior to the final adjudication of such disciplinary action. So with that, I want to stop and show people something else. And let me blow this up. So I don't want people to just guess anymore. We're going to learn how to read a statute. How you like that, Alphonse?
Yeah, so, I mean, here's one thing that throws them off, that term individual, okay? Here's what an individual is. It's a single person, okay? So even though, think about like McDonald's, you have a corporation with tens of thousands of employees, okay? But they're considered as a single entity, as a person, okay? An individual would be like Joe the plumber that went to the state and then registered a business license with the state, and he's one employee, okay? Joe the plumber is an individual, okay? He's not a corporation, most likely. He's probably operating, like you said, a sole proprietorship or something, that's probably how he's working. So that's what an individual is. People get confused and think, well, gee, that must be me, individual. And think about that list. Remember in school you had sets and like things had to be put in the set? Well, everything after individual, think about it this way. Everything that Brandon read after individual is what's called a legal entity. It's a registered legal entity with the state, okay? Registered legal entities operate by statute and charter, basically. This is where their rights and duties and obligations come from. They come from statutes and they come from their charter, okay? Now, you and I, if we were an individual, we're different than everything else in that list because everything in that list works by statute and charter. Brandon and I don't get our rights from statutes and charters. We have inherent natural God-given rights that are secured by the Constitution. So you can't put us in that list with like 7 other things that operate by statute, and we operate by Constitution. Well, that's where our protections are. So you can't put an unlike thing like us in that list. That's why an individual cannot be a man or woman. It must be a legal entity, most likely having a license from the state and doing business within the state. That's what the definition of a person is. It's a legal entity registered with the state, doing business in the state. That's as clear cut as what I can tell you is what a person is.
That's right. So what we're going to do, I'm going to use the Health Defense Freedom Defense Fund's injunctive relief against Joe Biden in the United States government, which was granted in by really, it's a group of people. There was 3 people who had standing in this, but this lady's out of Iowa, and there's a group of people up there that run the Health Freedom Defense Fund. They have 18 current cases going. They've got the injunction for the CDC, and in this particular injunction, they didn't even get outside the administrative code of the CDC and its limitations of authorities. But the beautiful thing inside this particular case is how the courts read the statutes. Okay, and for many years, up until probably the last 6 months, I didn't correctly understand. I understood that an individual couldn't be what it is, but let's see what the courts read it as. The rules of statutory construction. All right, statutes, dictionaries. To aid in statutory interpretation inquiry, dictionaries provide only a what? Helpful starting point. Statutory construction is a search for ordinary, contemporary meaning of terms in their context. Okay. When interpreting a statute, words that can have more than one meaning are given content by their what? Surroundings. Okay. All right. Let's keep on going here. I know I put some more in yellow here. I guess I didn't. Brandon, did I not finish it? But anyway, let's go back up to the statutory construction. Okay, so let's go back to that. I guess I stopped somewhere. All right. Plain language. Would determine the meaning of a statutory provision, the court looks first to its language, given the words used their ordinary meaning. If a term goes undefined in the statute, courts give the term its ordinary meaning. When interpreting a statute, a word may or may not extend to the outer limits of its definitional possibilities. Whether it does depends on reading the whole statutory text. When interpreting a statute, words that can have more than one meaning are given content by their surroundings. So we'll go to 14. To aid in this statutory, that's why I love Westlaw. You saw what it allows you to do. Okay. To aid in the statutory interpretation, inquiry dictionaries provide only a helpful starting point. And what you'll see here is that the context in the context individual is defined by the words that follow it. So if it's a corporation, joint stock company, organization, everything else behind that word, then it can only be one thing and one thing only: a sole proprietorship. That's it. It cannot be the living, breathing man or woman, because it would delegate everyone to involuntary slave status. It would be a violation of your rights to substantive due process.
And why wouldn't they just say everyone in the statute? Instead of breaking it down, why wouldn't they just say every man and woman, every corporation? We're done.
Well, yeah.
Every man, woman, and corporation. 3 words. But they specify. There's a reason they're doing that.
No, and so if you go read the criminal statutes, what does it say? All persons. It does not delegate. It does not deviate. It says all persons. Period. Louisiana's does anyway. It doesn't list out anything. It says all persons, no matter what. I think it says incorporated or unincorporated. It doesn't matter. All persons are bound by the criminal statutes of Louisiana because we're a civil law state. And you have to understand that now. We're a civil law state. So, but the common law still can be used here too. Is something I found pretty cool. So let's go back to the administrative law and start reading from it and help some people out. Administrative law is concerned with the legal problems arising out of the existence of agencies which combine in a single entity. Back up. Where's the separations of powers? Legislative, executive, and judicial powers, which are traditionally kept separate. There's only one reason why you would intertwine all this, and that is to override the rights enumerated in the Constitution. It is also generally concerned with the problems of administrative regulation. All right, he who creates controls. So all creatures of statute are bound by the statute. That means if you go call up the secretary of your state, you want to register a business and you want to get a license, you are now under the direct control and authority of the state. They have given you the license. Okay. That is their administrative function. Somehow that administrative function has made it all the way out to mining your property, right? And they are restricting all the fundamental rights that we have. Go ahead, Alphonse.
No, that's really what it is. It's if you read what a creature of the state is, they actually use the term creature of the state. It means a creation of the state. And there's a term in there that'll say the absolute authority power over the creature is defined. The creature becomes a resident of the state, right? An inhabitant of the state. So here's why they got people confused. They'll call you resident and stuff, like whether they're citations or whatever, local code guys. A resident basically is identical to an inhabitant, okay? They are one and the same. They're just a different term. It basically means a member of the corporation. You need to understand this is administrative law. Think about this now. Only the state legislature, which is a combination of the Congress and the Senate, which they call the Assembly, put together, only they can make laws. They can write laws. And Brandon, can't delegate powers to somebody else, can you? Once you're delegated lawmaking power, you can't delegate it to somebody else, could you? No. So they can delegate certain powers to the municipalities. They could delegate administrative law powers to them, basically saying, hey, to run your little municipal corporation, you can, in a way, act like a quasi judicial administrative law process here. You can pass your own ordinances and your own resolutions to tax and to regulate members of your corporation and the businesses within your boundary as a municipality. See, that charter allows them to do two things, that municipality. They're designated a territory. They give them, they draw invisible lines around an area and say, this is the Township of Aston's territory. That allows the Township of Aston to collect business taxes from McDonald's, Taco Bell, whoever's doing business within their area, they can collect taxes from. And for that privilege of collecting taxes, they've actually agreed to provide services to the people. Over the years, they've got you and I to believe that we're supposed to be responsible for paying for these services. That's not how it was established. That's not how it's actually set up now. It's just how it's being enforced. And it's being enforced like that because we've all become dumbed down and have basically we don't have rights here right now. You only have rights if you understand what your rights are and how to enforce them. Unless you can do that, you don't have any rights. It's like I said, it's like having a jet fighter in your driveway, and you can't even get in the cockpit of it. Yeah, I got rights. They're sitting out there in the driveway. Don't know how to use them, then you don't have them. If you don't know how to invoke them and how to use them, you don't have them. So all your local municipalities you're dealing with, they're operating, as Brandon's telling you, under administrative law. They're not operating under judicial law. They're administrative law agencies. And they're pulling you into that agency by calling you an inhabitant, a resident, a member of their corporation. We call it like the magic trick, basically, that they're pulling on you. They're with your mind, pulling you into an administrative court, and you don't know the difference that you're not in a judicial court here. You're in an administrative court. So,
well, we can do this too. Let's take this back to your hearing yesterday. Let's go down this rabbit hole. All right, and I'm dealing with it too. In somebody that I'm helping, get just a summons and one piece of paper. It's not a complaint. It is not a complaint. It doesn't fit everything of a complaint. It has nothing to do with a complaint. It just says you owe.
Either got to be civil or criminal. It's got to be one or the other. And in each civil, look in your state's civil procedures and your criminal procedures, and there are exact elements of what's got to be on that civil complaint and what's got to be on that criminal complaint. What Brandon's talking about with that letter she's got or wherever that document is, it's missing all kinds of key elements. So it's neither civil nor criminal. So we don't know what it is.
Right. And so, you start and wonderfully started doing discovery and come to find out when you start doing this, you listen, folks, by our system of American jurisprudence, you have the right to face your accuser. Do you understand that? That means somebody's made a claim against you. You get to have your day in court and you get to present evidence to the fact. Okay. All right. We have constitutional law, which is the original limitation. Okay. And then everything else is underneath that. All right. That's just the order. The supreme law of the land is the Constitution of the United States. All treaties, everything else is underneath that. All right. Well, when I started helping this young lady and started entering stuff in the record like a regular civil proceeding, things started popping out that they weren't operating. So I had to go to the administrator and look, we'll do like this. Let me do this. Let me pull up the Administrative Procedure Act of Louisiana.
And Artie's in our little group here. Artie, to answer your question, Artie, no, they can't. My local township can't do anything on my property. They have no ownership or interest or taxable interest in my property. Okay, that's a fact of law. So they have no authority to do anything with my property. To paint my property black, they can't tell me I can't. Okay, if I want to let my grass grow 8 feet tall, it's none of their business. If somebody's got a problem with something, they've got to sue me in court and bring a valid cause of action against me and plead how my property or what I'm doing is causing them harm or damage. Your township, they can create ordinances and resolutions. They can only use them on inhabitants which are members of the corporation And any businesses that are in contract with them doing business in their area, they can impose their ordinances and resolutions upon. Listen, Artie, I have already proved through 2 townships where I live and where I got rental properties that they can't impose their ordinances upon me. I've been 3 years. I've knocked them on the rear end every time they've gotten in my face. So no, they have no recourse to come at me. If they've got a cause against me, they better sue me. And me and Brandon were just talking about one before we came on, 1037A, Pennsylvania, that states, if any action, you read it because you can see it.
If any action is not commenced by a complaint, the protho notary, upon precipice of the defendant, shall enter a rule upon the plaintiff to file a complaint. If a complaint is not filed within 20 days after service of the rule, the protho notary, upon precipice of the defendant, shall enter a judgment of non-pros.
Now, me and Brandon were just talking about what a complaint is. There's either civil complaints or criminal complaints. And each one of them have specific elements of what they must have, or they're not complaints. That document that Brandon was talking about, this woman got, guess what? That's not a complaint. It doesn't mean a civil complaint. It doesn't mean a criminal complaint. So in this instance, if she was in Pennsylvania, I could do a precipice to the notary, to the profanatory, telling her, serve them that rule. And what that rule tells them is they've got to sue me within 20 days. Guess what? They're never, ever, ever going to sue me. You know why they're not going to sue me? Because they have no cause of action to file against me for not following their ordinances or their resolutions. They have no cause of action to impose upon me to follow their ordinances or resolutions. Because the only possible way they get me in a civil action would be a contract breach. I don't have any contracts or performance contracts with these people. So they can't bring a breach of contract action against me. So what the heck cause of action could they possibly file for me not following their ordinances or resolutions? How about zero? Nothing?
Yeah.
Okay.
Well, hold on. Well, let's just put it in the perspective. Okay, so this phony baloney law firm bringing an action for the fictitious plaintiff, okay, writes this single sheet of paper stating that you don't get to. They don't have to substantiate the claim. They just make it. They put a lien. Yeah. Hey, there's no cause of action. There's nothing in there that you're defending. There's nothing. Now, if I was to go do that, what would that be? Failure to state a claim in which the court can grant relief. Get out of here.
Brandon, let's touch upon this. Let's relate it directly to people, their understanding. When you say you get a code idiot writes you a citation because you didn't get a permit to put a roof on your house, okay? And he writes you this little fine, whatever. Here's what happens. They'll give it to their law firm, or the code guy will file it. They'll file it with the profanatory, which is basically the clerk of the court, okay, your municipal court. Guess what? The clerk of the court, she don't work for the court. She's a county employee, okay? I was stunned when I found that out. I thought she was a court employee. They said, oh, no, she don't work for us. She works for the county. So here's what happens. The lawyer creates a phony lien against you, a claim or a lien. It's called a claim. He'll start it. When he files it with the profanatory, she's just a glorified secretary. She's a clerk. She gets it. She turns it into a judgment against you and converts that judgment into a lien. Was there any due process in this matter? Were you ever notified beforehand to defend against this? No. There goes your due process right out the window, okay? Was there any service of process in this matter? No. Service process means, like Brandon's talking about, a process server knocks on your door and says, Mr. Sibley, you've been served, okay? You're being sued. They send you something in the mail. That's not process of service. I don't care what they say. That's not process service. There's a reason we pay process servers $150 to serve documents, because it's how we initiate court cases. Otherwise, I could slap a 50-cent stamp on there and start a court case by just dropping it in the mail. They're not going to let me do that. I can't start a court case by dropping a letter in the mail, and neither can they. Neither can your township, your borough, or your county start a case like that.
And so that's how you know how illegal the IRS is too, by the way, because they send things by regular mail to old addresses so they can go to their administrative freaking tax court and go get a judgment against somebody. Make no mistake, folks, the U.S. tax court is completely administrative. It is not a real court. It is an administrative functional court. And so they send things by U.S. mail, hoping that nobody gets it. And they just go get a notice of deficiency, turn into a default judgment. And most people get their eyes batted out their head because their bank accounts are seized. And it's all by fraud. It's fraud.
No. And here's how corrupt these local courts are. I served this rule upon the township where I live. I sent it to the clerk back in back in October. I sent it to her, okay? Back in October of last year, I sent it to her. She would not issue the rule. It's plain as day. You could read it. There's no ambiguity in that rule. She would not issue the rule. You know why she wouldn't issue the rule? Because I just blew up the entire tax system in Pennsylvania, the local tax system. Because anytime somebody comes at you, you could serve this rule upon them and they could never sue you for not paying taxes. Not going to happen, okay? So she wouldn't do that. So I had to push to get a hearing. And Brandon heard the audio, the hearing. The judge, now get this. We know that clerks can't issue judgments. Clerks are not courts of judicial, they're not judges, okay? They're not courts of competent jurisdiction, a clerk. They can't issue judgments against people. That'd be a violation of what, Brandon? Due process and a violation of your right to trial by jury. So the clerk can't issue judgments against you, but she will. So I'm in this court process, and the judge says, well, he's trying to give me, he said, well, let me give you a roadmap on how to fix this. He said, listen, file a precipice to open the judgment. I said, no, there is no judgment. Why would I file? It's called a precipice to reopen the case, or reopen the judgment. Why would I file a petition to reopen a judgment that doesn't exist? We know the clerk can't issue the judgment. Why on earth would I file a petition to reopen a judgment that doesn't? No, here's my standing. Listen, when push comes to shove and I take it to the federal district court, there ain't no way anybody's coming in and saying that clerk entered a judgment, because clerks don't issue judgments. And there's no way they're going to answer that in a legal pleading that clerk issued a judgment, because it's so against the Constitution. You couldn't get any further away from the Constitution. So that's not going to happen. The corrupt judge was trying to tell me that my remedy was to file a petition to reopen a judgment that never existed. I said, no. There is no judgment. That rule upon them and let them sue me within 20 days, or I make this all go bye-bye. So this is what's going on with your court systems, your local court systems.
Yes, and so I'll read this. So guys, listen, when I found this, the light went off for me. And I'll just tell this story to y'all. I don't think I've told it yet, but so I had an issue with a family member deciding to call the Wildlife and Fisheries on me, and Wildlife and Fisheries executed a warrantless search and seizure of property that was exclusive to me. So I called up each of the agents, started doing my own investigation, got all the details out of all of them, and that's how it works, folks. Got all the details out of them, called the Secretary of Wildlife and Fisheries, put in a records request, notified the Secretary, said, oh, by the way, your agents conducted a warrantless search and seizure without affidavit of probable cause of any criminal activity being committed. And here was the funny thing, because as this is going down, I'm researching the offenses and the citations of the Wildlife and Fisheries, and I come upon reading all the. Here's the key, folks. Just don't say something. Go read the statutes. Go read their authorities. Actually go pull it up and find the limitations of their authorities, and you're going to be pretty surprised that it's been there the whole time. Yes, we have been dumbed down. We don't know our substantive rights. We don't know what due process is. We think the local kangaroo court judge up here actually has the authority to do what he's doing, but no, it's turned into a business model. Okay, everything's a business. Okay, but the truth is that when I went and read the Louisiana Administrative Procedure Act, it read as dust. I told you it was Article 49. The Louisiana Administrative Procedure Act is the law. Hold on, let me go back to that. Wildlife and Fisheries can change their code anytime they want. The Transportation Code can change anytime they want. The law governing the administrative policies that can't change, okay, is the Administrative Procedure Act. For state administrative agencies to propose and issue regulation that provides for judicial review of agency adjudications and other final decisions in Louisiana. So what each of you can go do is pull up your own Administrative Procedure Act. It's going to be so the rules of civil procedure of Louisiana, the rules of evidence of Louisiana for normal operating courts are explicit But for the administrative courts, where are they? They're in the statutes. And so when I started going to read the statutes, we'll go back and we'll start flipping through here. I've got a few things just to itemize for y'all guys. I don't just do this for nothing. But we'll go. There's one place I got highlighted that I want to show you. I'll get to it. Just give me a second. I can't remember which one it was. I highlighted it. Well, I guess I lost it. Whatever. But anyway, inside here, it actually tells you, see the judicial rules and everything else here. You start getting into the actual quasi judicial rules of the courts and all that stuff. Oh, here it is. The court may affirm the decision of the agency or remand the case for further proceedings. The court may reverse or modify the decision if substantial rights of the appellant have been prejudiced because the administrative findings, inferences, conclusions, or decisions are what? What's the supreme law of the land? In violation of constitutional statutory provisions, in excess of the statutory authority of the agency, made upon unlawful procedure affected by other error of law, arbitrary or capricious or characterized by abuse of discretion. So let's go back to this thought process here. The Louisiana Constitution enumerates in Section 27 of the Louisiana Constitution that all men have the freedom to hunt, fish, and trap all aquatic life. Can there be a restriction of that? No. It states all men. So where does the restriction come from? The regulation comes from the administrative side. It has to come from agencies or instrumentalities or businesses, people out there trying to sell. There's good reasons for this. You don't want somebody out there fishing and selling, let's say, blue marlin, but he's really catching mullet.
Right.
Okay. There's good
these agencies have their purpose. They're actually put there to actually make it easier to govern things. Okay. But what's happened is the people that are working there have no understanding of law and no understanding of their limitations. And they're just imposing it upon everyone when it's not meant to do that.
Yes. And that's the truth. I am not anti-government in any kind of way. I'm not. But what we have is a completely dumbed down society. And listen, Gary went back to the courthouse today. Okay. We have an injunctive relief that we're writing. And we're almost finished with it against the United States Marshals. He went up there again today, one last time. By the way, the Louisiana Supreme Court ruled 3 weeks ago that the mask mandate is unconstitutional. Okay? Now, guys, that ruling applies to who? Everybody. That's the full faith and credit clause of the United States Constitution. Okay? How many people did they publicize that ruling by the Louisiana Supreme Court? Here it is. Here. Let's just do it for everybody so they see it. I don't know how many people actually know this. This is the Supreme Court of Louisiana on the 13th day of May 2022. And this was a granting of a motion to quash. And they called John Bell Edwards, the governor of Louisiana, his mask mandate unconstitutional. Now, you can incorporate this in any pleading that you have on any mask mandates or anything else because they're all unconstitutional because they violate the rights of property, the rights of privacy, and the rights of freedom of conscience. That's just simple. We had a great ruling right here. Let's see if I can. I'll upload these documents to Telegram, but Telegram's already got them. We're already discussing these ideas. We have great, wonderful people ruling perfectly right now. We've got our opportunity to get in these courts and really cause some good damage, box people in their ears a little bit, and wake the masses up who are just fast asleep at the wheel. Look, there's only one way men of less intelligence learn, folks, and that's by experience. They're not going to learn until something kicks them in the ass. I'm sorry. That's just the way it is. Go ahead, Alphonse.
No, listen, there's people say, well, codes and statutes don't apply to men and women. Listen, it depends on what the code and statute is. Like Brandon said, the criminal statutes and codes, yeah, they're going to apply to you, okay? If you murder somebody, guess what? You're a person, okay? You're not going to get away. It depends on the, like he read the statutory construction. It depends on the context in which it's taken, okay? If you're talking about tax code and you're talking about corporations, no, that doesn't apply to me in that context. But if we're talking about criminal law things, about stealing or assaulting somebody, yes, the statutes and the codes are going to apply to you. So don't just go with that stupid thing and just say statutes and codes don't apply to men and women. Depends on the context of the statute and code. Everything's unique and separate. You have to look at the context of what they're claiming against you and then attack it from there. But you're just not going to go in there with a citing and say, hey, listen, if you put that in your paperwork, hey, listen, statute and codes don't apply to men and women, they're going to write you off, okay? Now that's your opinion. You're not going to find any AmJur cases where they're going to say statutes and codes don't apply to men and women. No, you've got to deal with that particular code or statute and in the context of how they're trying to relate it to you and what the charges are. Then you can attack it and prove that this particular code or statute doesn't apply to me, and here's why. That's different
right.
than just saying this all they don't apply. Come on.
Well, and when I talked to the Secretary for Wildlife and Fisheries, I said, hey, listen, I understand the limitation of your authority is outlined in the Administrative Procedure Act, and you don't have any business going on my private property when clearly all the signs up on the building said no trespassing. That means you can't. In order for them to get on that vessel, they had to have a warrant, an affidavit of probable cause of a crime being committed, and none of those elements exist for that to happen. Okay, none of those elements exist. So what they did was do a warrantless search and seizure. So I've got another lawsuit coming up, and this is the beauty of this. When you do finally put all this together, I think Steve Emerson says this too. You never run out of idiots to sue.
Target-rich environment. Okay. Yeah. Here's the hardest part for me. Trying to decide which one to finish first, which to hit, because they're coming at you so quick. You're like, I could move this, I could move that, and I can move that. So you start moving one thing and then something else happens. You go, oh, let me address this. You got to like set it up in a list. I'm hitting this first. I'm hitting this next. I'm hitting this next. Okay. You're never going to be sitting there going like this, twiddling your thumbs going, gee, I don't have anybody to sue. You'll have lawsuits till you're 90 years old if you want to file. There's always going to be stuff. Once you understand the rules, you're going to understand how outside the rules these people actually are operating. And listen, there's nothing like looking at an attorney and telling them, hey, sir, you committed forgery by filing that lien against my property. That's securities fraud. You have no authority whatsoever to file liens against property you don't own and you have no interest in. And you should see the look on their face when they see someone confront them with that. Because here's how this works. When I sue Mr. Attorney in federal district court, he cannot come into court and say, hey, this statute gave me authority to do this to Mr. Faggiolo. That's not going to happen, okay? So when you learn these rules and learn these procedures, and Brandon's going to touch on it probably coming up, take that jurisdictionary course. It's the best $250 you're ever going to spend, because you're going to learn how the process works, and you're going to learn what the paperwork is and how courts have to proceed and what the different documents are. You've got to have those fundamentals, or it's like you're trying to play a card game and you don't know the rules of the card game. You're playing card games with all these sharks and you don't know all the rules. You know some of the rules, but they know all the rules. You're going to lose every time. They're going to smoke you. And that's where most of you people are. You don't have the rules down there. Here's the powerful thing, though. Even though these attorneys have had $250,000 educations and 30 years of advanced training on you, real life by working, once you learn what they learn, and you're probably going to learn it through jurisdictionary better than they actually know it, okay, believe it or not. You're going to learn more from that jurisdictionary course than what the average lawyer knows. Now, here's the power of this. Once you have these skills down, you can do things that attorney A won't do, and B, he can't do. So now you're more powerful than that attorney because you can do things that he can and won't do. You have no limitations. You don't have to worry about that judge that you're before. I didn't worry about the judge in that hearing I was at. I talked to him how I wanted to talk to him. That attorney, he's on eggshells. He's walking on eggshells in front of that judge, because he might see that judge for the next 10, 20 years of his career. And if he pisses that judge off, that judge could snatch that bar card away from him through sanctions and different stuff. So that attorney, that's another reason why we tell you not to use attorneys and move your own case. Because that attorney at a certain point, he won't do something that could help you if it's going to hurt the municipality, or he knows the judge is going to look down upon it. Okay? This is why you've got to learn this stuff yourself. And it's not easy to do, okay? But the thing is, it's not that I think I could teach this to anyone, Brandon. I don't think there's not too many people I couldn't teach this to. No, it's just a matter of will.
Yeah, it's not as complicated as you think. The number one problem with everybody, myself included, and you'll even admit it too, Alphonse, is the amount of bullshit that you got to unload to get to the truth, because we've been programmed with so many legal gurus and crap. That is the hardest thing for people to let go. And here's the truth, folks. Every single one of us have the equivalency of a 4th grade reading education, and yet we want to go read law documents. I'm sorry, you're going to have to up your reading comprehension and your ability to focus. You can't be like a goldfish in a bowl going squirrel all the time. You actually have to have a little discipline, a little self-mastery, and a little self-control. And what you'll find is that not every court is corrupt. Not every judge is corrupt. And with that, before I forget, I want to play this little 1-minute excerpt from you yesterday, Alphonse. This is wonderful. When you don't just talk it, you actually do it. Okay, that's another level. When the wildlife and fisheries come at me, I went after them like a bull in a china closet. I did. I lost my cool with Agent Trey. I did. I really did.
I did that too.
Gary knows how worked up I was that week. I was worked up, dude. I was mad. I was angry. But at the end of the day, you're fighting for truth, justice, honor. These people are just intellectual prostitutes who fawn at the feet of mammon. Okay, that's it. They have no inner held conviction. They're just doing their job. They're everyday button pushers. That's it. Okay, let's listen to Alphonse now. This is yesterday, Alphonse's court hearing. Y'all let me know if y'all can hear this.
It's a little low.
Listen, you don't have personal jurisdiction. There's no service of process inside. There's no subject matter jurisdiction. There's no complaint filed. And he's got no standing whatsoever. There's no in rem jurisdiction because they have no ownership or interest in the property. You can only bring an in rem action when you have ownership or interest in the property. You can't have an in rem action without ownership or interest. Is there somebody from Aspen Township here to testify that they have ownership or interest in my property? Because Mr. Pierce has no standing. He's got, for Rule 602, he's got no personal knowledge of anything. He could be here to testify. He don't know anything. He's got no personal knowledge. He's going by all third-hand, whatever somebody tells him. Is somebody here from Township going to ask him to testify?
And I like that. I like that.
Crickets here for about 30 seconds. Wasn't there? There was crickets.
I'm going to keep letting it play, but I just want to make a point while we're here, right? Because this goes back to the foundations that we're talking about, okay? So Joe Blow doesn't just get to make a claim against you, and there's nobody out there that has, for civil matter, some type of ownership or interest or some type of valid claim for redress of grievances, okay? That's it. So they're doing this quasi-judicial administrative move here, and nobody there has standing. And what is standing? The ability to sue.
Right. Here's what that was about too. Is here's what they do with you with these this local tax issue. So like me and Brandon were talking about, they never gave me service of process, so they never have personal jurisdiction in the matter. Okay. The municipal claim they file is not a complaint. It's not a civil complaint, and it's not a criminal complaint. So it's not a complaint. Without a complaint before that court has no subject matter jurisdiction. Right there, that court can't hear any matter. I don't care if it's administrative or whatever it is, that court can't hear any matter. But they try and be slick with this administrative law. So here's what they do through statute. They claim that they only need in rem jurisdiction, which means it's an action against your property, an in rem action. It's like saying it's an action against your house, okay? They're bringing the action against your property and your house. They're saying it's an in rem action. Well, when you go read American jurisprudence, and I read tons of stuff on in rem in American jurisprudence, and it's clear as day. Here's the only way a court gets in rem jurisdiction over property: if they seize the property in the commission of a crime. So if it's a gun that was used to kill somebody, they seize the gun to be used for evidence. The court has in rem jurisdiction over the property, okay? They don't have in rem jurisdiction over my property. Doesn't matter whether it's registered with the county or not. They don't get in rem jurisdiction of it. So the township moves this in rem action against you. But when you read American jurisprudence and you read these ton of court cases I read, you need to have ownership and interest in the property before you can bring the in rem action. So the attorney that filed this crap against me, he don't have ownership or interest. And the township he's claiming he's representing, they don't have ownership or interest. He had no legal authority whatsoever to file an in rem action against me. And that's what that exchange was with that judge. I'm trying to say, you don't have personal jurisdiction. There's no service of process. You don't have subject matter jurisdiction because there's no complaint before this court. Plus, here's another beautiful thing. And Brandon was talking about the full faith and credit clause. There's a great citing from a Pennsylvania court cases. Then they just fall one into the other. And it states, when a cause of action is created by a statute, that's every traffic citation, that's every violation, that's every local tax thing. If a cause of action was created by a statute, it states there must be a party with standing in the matter. And it goes on to define that standing means someone that's been directly affected, not sort of affected or might be affected, directly affected by the matter. Because without standing, that's a judicial prerequisite. That court can't hear that case. So in this little exchange you're hearing, the township doesn't have standing, and the attorney doesn't have standing because they have no ownership or interest in the property. They're done at that point. And the reason for this hearing was that Rule 1037A that Brandon read earlier. They didn't want to serve, that clerk would not serve that rule to the township. I had to kick and scream to get this hearing, to get it on the record that, hey, Mr. Judge, your clerk evidently don't know what she's doing. I'm going to need you to serve this rule to the township. And here's what the judge said about the clerk. Well, she didn't really understand what it was. Wait a minute. So she'll send the sheriff out to somebody's house by signing a writ of Sir Fossey to steal their property from them, but she don't know what this precipice to serve the rule means. Wait a minute. Then she's not properly trained. She shouldn't be a clerk, okay? And let me get this straight. She works in a courthouse with all these judges, okay? She couldn't take my filing, which is all, I didn't make it up. It's not something I pulled out of my rear end. It's actually a thing. It's a precipice for them to file a complaint. She couldn't take it to a judge and say, hey, Mr. Judge, what do I have to do here? Because Brandon read it. He understood it. I read it. I understood it. The clerk of the court, who they're all attorneys, they're all former attorneys, most of them. You mean she didn't understand that? So that's what this hearing was about, was basically just putting this court on notice, this quasi judicial court, that, hey, I got your game down. You don't have jurisdiction to be doing anything in this matter. And that's what that was about.
Well, let's finish this up and see how it ends, because it's pretty powerful how you end right here, Alphonse. I like it. I like it. Just state the facts. They're sitting now. I want to give y'all a pause. The pause here is Alphonse asked a question. How did the court gain in rem jurisdiction in his property when he has exclusive ownership? They're sitting there. Okay.
It's awkward. It's awkward.
Can the court explain to me how you have in rem jurisdiction on my property? And it's like crickets. Chirp, 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 chirp. Okay.
I want to know how this court claims they had jurisdiction to even initiate this matter. Where did you get in rem jurisdiction of my property? Can someone please explain that to me?
Chirp.
Mr. Pierce explain it.
I provided whatever additional testimony
All right, hold on. I just want everybody to hear what the judge said. He's asking the attorney now if he wants to provide any more witness testimony or anything else. Listen, guys, this attorney has no ability to testify to any matter whatsoever. And Alphonse deals with it very succinctly. It's an objectable matter in any court because the counsel cannot testify. He is a third party witness. He has no firsthand personal knowledge. He's little more than a little circle jerky jockey. That's it. That's all he is, and that's all we need to treat him like, because there's no membership organization or group of people who have caused more harm to this United States of America than these phony baloney bar members and their continued destruction of the English language and hiding behind their obfuscation and all their little statutes and everything else, where they paint everything in real pretty like, and then they go defraud the people so they can sit around and sit in fat houses and everything else with no conscience because they have no internal conscience of God.
What's that Bible citation? Woe unto you lawyers.
Woe unto you lawyers. That's right. Because they have no conscience. You almost have to be a sociopath to be one.
I don't know that I have anything because, again, Your Honor, I don't know where I'm supposed to go with this.
I'll standard legal process.
Did I interrupt you, sir?
Sir, you shouldn't even be here.
So what happened was, like Brandon said, the judge went back to the attorney and asked him, did he have any more to say? And he said, I don't really know why I'm here. Then he said something like, I don't really know why I'm here. And I said, sir, follow standard legal process. That's what you and I are entitled to. Standard legal process. Sue me, okay? And he turned around and said to me, sir, did I interrupt you? I said, sir, you shouldn't even be here. You have no authority to even be speaking right now, let alone to be here. And
well, why are we
ended right there?
Why are we going to give them opportunity to put anything in the record when they have no? They listen, guys. They have no business speaking. None. Okay. There's no client that they're representing that has a living, breathing, sentient that actually has claim or interest or ownership in anything that's going on in there. They're completely hiding behind a fictitious plaintiff, moving a fictitious complaint against somebody. That's it. That's really, it's a facade. It's a facade. And so everybody in America takes these quasi judicial courts and applies it to all courts. And that's not the case. There's bad judges. We got a bad judge right here at the Middle District of Louisiana. We're going to have to do injunctive relief against her. And guess what we're going to have to do with all our cases? We're probably going to have to long arm our cases after we do this. Why? Because we're filing injunctive relief against her. Or we'll just have to recuse her from the cases. But make no mistake, the battle's starting. And the lines are drawn in the sand. There's no giving up. You're standing for principles of truth and what's right. Okay, that's it. That's all you're doing. Either abide by the rules that have been set forth, or just simply throw them out the window. But these rules, the more you dig into them, except for the administrative courts, the administrative courts are there to trick you, no doubt about it. But
now, that hearing that you just heard, here's what that hearing does. Listen. I've told that judge right out, you don't have jurisdiction in this matter. And guess what? He knows you don't have jurisdiction. He proceeds to act without that jurisdiction. See that immunity judges have? Bye-bye. As soon as he acts outside of his responsibilities and duties, he can't act without jurisdiction. He knows you don't have jurisdiction. I'm sitting there asking him, how did this court get jurisdiction? Is there anybody from Aston Township coming up here to testify that they have in rem jurisdiction over my property? And there's crickets, because they know that's the elephant in the room I just pointed out. Because guess what? Most people, Brandon, when they get these complaints, they miss the in rem part up there in the heading of the in rem, or most don't understand really what that means. That means an action against your property. Well, guess what? If somebody brings an action against your property, they need to have ownership or legal interest in your property. When you register your property with the county, you do not waive any rights in your property. You do not grant them any ownership or interest in your property when you register your property. Doesn't matter whether you register your property with the county. You're supposed to register your property with the county. That's only done to stop land disputes, so that somebody don't come along and push me off my land and say, this is my property. I got records filed. This is my property. That's what registration's for. But what they've done is these little public servants through the Bar Association, direction from the Bar Association, have bastardized the system by taking every square inch of property and every person within their territory and taxing them. Okay? They don't have authority to do that. That's not what the registration process is for. So that's what the purpose of this hearing is. The powerful thing about this is when you spell it out and you lay it out in your paperwork, when I sue this guy in federal district court, this dumb attorney, and I name the judge as a defendant, he's going to have trouble trying to use his immunity to get out of it. Because there's no way he's going to have to be explained how, sir, you didn't understand you didn't have in rem jurisdiction over Mr. Faggiolo's property? Why would you proceed in this matter? He can't, he's going to have trouble getting away from the facts of the case. Now, these are just the basics. I'm moving on. Jurisdiction. You could, right there, I just taught you what jurisdiction is in three things. To get personal jurisdiction, you got to have service of process. It's the only way a court can get personal jurisdiction. Guy knocks on your door, Mr. Faggiolo, you've been served. Like Brandon said, the complaint and the summons, it's got to be in there, okay? And tells you got, what, 20 days to respond, okay?
I think it's 21 days. In Louisiana, for the Fifth Circuit, it is 21 days.
So there's personal jurisdiction, okay? You got to have service of process. Them mailing you a letter, that's not service of process. That's an administrative law process. That's not judicial process. So they don't have personal jurisdiction. In order to have subject matter jurisdiction, here's where they'll throw a lot of people off. They'll say, Brandon, we can hear traffic court cases. We can hear tax cases. Yes, you can. Doesn't mean you can hear my case. Okay?
That's right.
Doesn't mean my case is a tax case or it's a traffic case. The only way they can get subject matter jurisdiction is somebody's got to have a civil complaint or a criminal complaint filed against you, okay? A civil complaint means a verified complaint by a real party saying how they were harmed or damaged by you, okay? That's what a civil complaint is. A criminal complaint must have a warrant of probable cause.
An affidavit of probable cause signed by a first-hand witness and that testified to the witness of a crime. And here's one big thing too, because they don't do that. They do not do that, and then it has to. So Louisiana, and I'll just stipulate this point too, it either has to be issued previous to the search and seizure of time or within 72 hours of the arrest or seizure of property. So
yeah, you can't get a warrant without an affidavit.
Right.
You got to have the affidavit first. Somebody's got to sign an affidavit saying, "Hey, this guy Brandon, he's doing all these bad things at his property, Judge. I need you to sign this warrant so I can go stop him." You got to have that. That's the affidavit of probable cause. And like Brandon said, how about probably 99 times out of 100, if you get copies or certified copies of the file, and it's a criminal action, you probably won't have an affidavit of probable cause in there. So there's another way you attack them, okay? So that's your subject matter jurisdiction. The third way they try and move against you, which is so outside the Constitution, it's unbelievable, is an in rem action, okay? In rem action, guess what? That is an admiralty action. That's an action that they use at sea where they actually seize a ship, the cargo of a ship, okay? That's what in rem was basically. That's where that came from. It's an action against your property. But the only way that they can bring it, somebody can bring an action against your property is you must have A, ownership of the property or the legal interest in the property. If me and Brandon own the property, like whatever, 50-50, and we had a dispute with each other, and I sued Brandon involving the property, and I brought an in rem action, I could bring that action against Brandon because I have legal interest in the property. But if I have a dispute with Brandon and I don't have any ownership or interest in his property, there's no way on earth that I can bring an in rem action against Brandon's house or his property. Can't happen. Well, it's the same thing with your local municipality or your county, whoever. They can't bring an in rem action against property that they don't have ownership in and they don't have interest in. So there's the three basics right there. Here's how you can knock out probably 90% of your actions that are taking place in court to prove that this court doesn't have jurisdiction to hear this matter. And when you use that Pennsylvania citation I mentioned, which I could post in it's actually posted up on Telegram now, it flat out states that, here's the beautiful part about that citation, and what Brandon was talking about, the full faith and credit clause. Because if Brandon lives in Louisiana, he could take that Pennsylvania citation and he could actually use it in his case, because I can't be operating under a separate set of laws than Brandon. Hello, 14th Amendment, equal protection under the law. I can't have more protections in Pennsylvania than Brandon has in Louisiana. Okay, so that ruling in Pennsylvania states generally subject matter jurisdiction and standing are separate matters. But if a statute creates a cause of action, which is every traffic citation, every code violation, every local tax you get, these are all created by statute. If a statute creates a cause of action and determines who may sue, there must be a party with standing. Standing means that you're directly affected by whatever I did. Okay, I had to do something that directly affected you in some way. No one from your county's been directly affected by anything you did. The cop that gave you the traffic ticket, he's not directly affected by anything you did. They don't have standing in the matter. Okay, this is the stuff you have to understand and get in your head and get the basics down. And once you get that, it's very easy to build off this stuff, because now you know where you can trip them up. Because when they throw things at you, you go, oh, wait a minute, you don't have this, you don't have that. Now, they're either going to let this thing go. It's either going to go off into the ether, which a lot of my things have gone on. Last 3 citations I had, one was mine and 2 of my buddy Carmen's. They went off into the ether, Brandon. They disappeared, okay? Everybody stopped contacting us. And nobody bothered us anymore. They didn't write us back and say, hey, we've dismissed everything. And they're never going to do that. You know why they're never going to do that? Because it's admission of liability. If they ever turn around and said, Mr. Faggiolo, we've dropped this case, guess what now I have? Not only do I have a common law abusive process that I can move against them, if they drop the matter that they previously tried to move against me and I got it knocked out legally by the judge dismissing it, now I can move in what do you call that? Malicious prosecution against them. Okay.
Right.
Now they just stepped into malicious prosecution. So rarely are they ever going to give you a document saying, hey, Mr. Faggiolo, you're right. We've dropped this matter. Because it'll be like handing me a malicious prosecution case. Here, Alphonse, go bang him over the head with this order that I gave you for malicious prosecution. So the way they generally deal with it is they will let the matter go off into the ether. They will just stop contacting you about it. You don't know what's happened with it. It just goes away. So.
Yeah, and I was just over here helping somebody in there. Hey, man, Meet, if you really want to help yourself here, you need to take the jurisdictionary course and understand that you had substantive rights that were violated on that. But to finish the idea of standing, this is the District of Columbia Court of Appeals, and you can see all this. Generally, to have Article 3 standing, a plaintiff must show that, 1, he suffered an injury, which means an invasion of a legally protected interest, which is concrete and particularized, okay, and actual or imminent, not conjectural or hypothetical. The injury was caused by person sued, and a court can likely redress the injury. That is standing. This is Article 3, Section 2, Clause 1. This is where it's coming from. Standing means the right to go sue, and you have to have a personal stake in it. You can't just willy-nilly. The township of Aston can't go, hey, by the way, we've got ownership or interest in your property over there. How you like that? Who said it? Well, the township did. That's a completely fictitious entity. Okay, this is a corporate body politic set up to regulate other corporate body politics, and it is not running at the same level of law as, say, this right here. Okay, that's just a fact. That's just a fact. Okay. And so with that, let's get back to the administrative law, because I want to finish this up, and then I'm going to share the complaint at the end, and we're going to go over some of these decisions that have come through and the importance of them. Okay. And why it is important for you. Nobody else can make these decisions for you or spark that fire within you to actually want to do this stuff. I can't do it. Everybody sends me stuff about how they need and want help. Well, the first thing I do is I load them up with 15, 20, 30 pages of stuff. When you get done with that, come ask me some questions. Okay. I'm at the point now where Gary and I have 3 cases ongoing. I've got the wildlife fisheries to do, and I've got those people that I'm already helping. I'm loaded down. There's no more I can possibly take on. But at the same time, if you do the research, I will continue answering questions, because genuinely, I do want to help you. If you don't put the effort in, if you don't put the $250 in, because what does the $250 for me and Alphonse really do, or anybody else? It takes away all that stuff you don't know, throws it out the window, and gives you a foundation to work from, to start asking decent questions, not hypothetical moot questions, right? Stuff that we deal with every day, like the David Straits and the David Windmillers, and the birth certificate and the social security number. These are losing avenues. We're not losers. We don't want to be losers. We want to keep going to these Article 3 courts and winning. Okay, that's what we're going to do. Okay, so with that, let's go back to administrative law and let's read a little bit out of here. Sometimes the language of private rights is used in the administrative context. However, this language may simply signify a policy relevant to administrative law, encompassing both public and private rights. Because administrative agencies serve in part to effectuate the constitutional obligation of the executive branch to see that laws are faithfully executed, the public interest is an added dimension in every administrative proceeding. This public good doctrine, folks, it's got to be destroyed, because without individual liberty, there is no public good.
No, then you're living in a democracy. You're not living in a republic. Then that's 51 right. Beats 49 every time.
Yeah.
So 51% of the people say they own your property, they'll come take your property.
That's right. That's right. And this is where we're headed, but we've still got enough people to stop it. In addition, the public rights doctrine impacts administrative agencies. In certain areas, the principle applies that particular administrative agencies are created to protect the public interest. And here's the most important part: and not to vindicate private rights. Okay? You have to understand this. That's not what
they don't care about your rights. They're not dealing with your rights.
They're not. That court, this quasi judicial court, cannot hear your rights. It doesn't have the jurisdiction to do so.
It's like McDonald's. It's like arguing the constitutional rights to McDonald's.
They're right.
They're just dealing with their administrative law. Hey, listen, you got to wear a brown uniform and you got to come to work at 9 a.m. each day. That's their law, basically. They don't care about your constitutional rights. Well, who says I got to work? They don't care about that. It's administrative law.
Where private common law rights are at stake, the court's examination of the congressional attempt to control the manner in which those rights are adjudicated will be searching. However,
searching. That's very searching. That means don't exist. Okay.
That means you can't enumerate them. Okay, so let's go back to this idea right here for the whole in-rem jurisdiction. Can a corporation own property? Yes, it can. Can a corporation invoke the liberties as secured by the Constitution of the United States? No, cannot. Only you can. The most powerful testimony that you can ever bring into court is what? First-hand testimony. It's the most powerful tool in your arsenal. Nobody else can speak for you. Nobody can plead the damages of you. Okay, however, Congress may create a private right so that it is closely integrated with a public regulatory scheme as to be a matter for agency resolution with limited involvement by the federal judiciary. These separation of power concerns are diminished where parties are not required to, but merely have the option of proceeding in an administrative form.
Have the option of proceeding. So when you show up to that quasi judicial court and you don't show up and say, hey, listen, I'm here by special appearance to challenge the jurisdiction of this court. If you just show up, they take that as, they call it a general appearance, which means they agree that you're agreeing that court has jurisdiction to deal with this matter. If you show up and say, hey, I'm here by special appearance, and that's a real thing, I didn't make that up, that's actually taught in Kaplan's audio seminar that the attorneys take before they take the bar exam. It's called a special appearance, and it's basically invoked just to challenge the court's jurisdiction. It's basically saying, hey, listen, I'm only here today to talk about this jurisdiction thing. I don't care about the charges or any other crap. I'm here about the jurisdiction of this court. That's what you do at a special appearance.
Okay. So this is the section. I'm going to read this. I didn't highlight it, but this is the section where I found that each administrative agency, their limitations were set out in the act. The feds have an administrative act, and so does each state. Okay. All right. Administrative law originated in the development of constitutional perimeters to circumscribe the administrative process. Later, these constitutional limitations were codified by statute in such acts as the Federal Administrative Procedure Act and the State Administrative Procedure Act. I'm not bullcrapping y'all or telling y'all, and you can go look at this. This is the case notes and the case law that substantiate it. When you finally figure out how simple it is, you're not going to be in the world of clown cuckoo land. You're just going to start with the basics. Jurisdiction. How did you get it? Right? Where did it come from? It just, one guy told me the other day, the judge told him, I've got jurisdiction because I say so. Good. Okay.
Right.
Now I'll slam you with some judicial complaints and I'm going to bam you upside the head. No, just because you say so, that's not a substantiation of a claim.
No.
That's not how this system works. The administrative system substitutes administrative agencies for courts and making many determinations in the establishment and definition of individual rights. However, differences in the origin and function of administrative agencies and courts prevent the wholesale transplanting of the rules of procedure, trial, and review, which have evolved from the history and experience of the courts.
In other words, we don't need to follow civil rules of procedure and those rules of evidence, right? Isn't that what that just says?
That's exactly what it says. Okay. So you've got us out here pulling up the state rules of civil procedure, the rules of evidence, and trying to go off these ideas. And yet this whole system is separated from that system. It's completely separated. They're not one and the same. And that's why Title 42 at 1983 is so easy to use against municipalities. Okay. Understand that, folks. It's set up just for municipalities, primarily for municipalities.
That's why they're considered persons in municipality. And
That's
listen,
right.
You can't sue the state directly, okay? But you could sue the employees of a state, okay? The employees of the state you could sue. But you can sue a municipality and their employees. In other words, the state government gave themselves immunity, not their employees. If their employees do something wrong, you can go after them. But the municipalities that are they're political, they're subdivisions of the state, basically. Okay, that's what your municipalities are. The state did not give them that protection, so you can go right after a municipality, just like you're suing your neighbor. Okay, and they can't hide from you. This is the beauty of that 14th Amendment that everyone hates. Okay, that's equal protection under the law. It's due process of law. And without that 14th Amendment, you'd never be able to get that state into court. I mean, that municipality into court and go after them. So be careful what you read on the internet from these people. You know, to me, 14th Amendment's probably that's probably my favorite amendment. Okay. I love that 14th Amendment because it just is all encompassing. Like me and Brandon were talking about. I can't be living under a separate set of rules than Brandon. Yeah, there might be certain differences with certain things, but in a serious case, I can't have certain rights that he doesn't have. Can't work like that. It's equal protection under the law. So if a case is decided one way in Pennsylvania, he could cite it right there in Louisiana and bang him over the head with it. Hey, here's what Pennsylvania said. Now, the best is to cite your state. You always want to cite your state first, as far as case law, your state first, the Supreme Court second, and then out-of-state decisions after that. And I've seen a lot of lawyers, Brandon, use out-of-state case sightings. You know why they did that? Because in Pennsylvania, like I helped somebody with a phony dog attack. The dog never touched anybody, never bit anybody, but they called it an attack, okay?
Right.
So the attorney that filed the paperwork, she had no good case sightings in Pennsylvania to pull up from. So she cited New York case law she brought in, okay? So you're free to use, with the full faith and credit clause, you're free to use rulings in other states. Like I said, always you want to use your state first, Supreme Court second, and then other states' rulings. And the way Brand was talking about earlier, the pecking order, and get this in your heads: Constitution number 1, legislative law second, which is your state laws. Okay, administrative laws third. Remember, he was just talking. Me and Brand talked about administrative laws; they're third on the list, and court citings are fourth. Court citings are not laws. I can't invoke a court citing as a law. I can't bring a case based on a court citing. The way I use court citings, it's to support something that I plead. Case in point, Pennsylvania states, I had 4 great citings in Pennsylvania, that if there is no service of process, for whatever reason, if there's no service of process, the court has no personal jurisdiction. Okay? So now I could plead, hey, Township of Aston never served me process. This court lacks jurisdiction. And then I pull up them 4 case citings and say, there it is. Here's the cases that used it, because no longer is that my opinion. If I didn't put those court citings under what I stated, they look at that and say, well, that's Mr. Faggiolo's opinion. No. When I pull those court citings in, because those court citings are saying just what I pled. Hey, the Township of Aston never served me process. This court never had jurisdiction in the matter. Now nobody can argue with this, because we have well-established case law from the Pennsylvania State Supreme Court. They're telling you right there, no service of process, no personal jurisdiction. That's how you use court citings, to support things, not to move things. That's my rant.
I'm good. Okay, so we'll start back up. Nevertheless, administrative proceedings may not be conducted as to violate fundamental rules of justice or permit informalities to prejudice the rights of parties. But that's what they do every day. Administrative procedure is generally simpler, less formal, and less technical than judicial procedure.
We don't need those stinking rules. We don't need them stinking. We don't need those stinking badges. Remember, we don't need those stinking.
Yeah.
We don't need those stinking constitutions. We don't need those stinking rules. That's what it is.
It's in general, strict rules of evidence do not apply to administrative proceedings. In addition, the right
forget about that. It's a copy, and it might have been falsified. It's not an original. We'll accept that. But wait a minute, he made it on a Xerox machine, and look, you can see the copy marks. Oh, we don't care about that. They can do anything they want in these administrative law processes.
And they can. And here we go again, what we've told people, that you're going to get railroaded most of the times until and maybe there's somebody like union member last week. That judge didn't want to test him, knew exactly what union had set him up for. And that was it. Hey, I'm not touching this with a 10-foot pole. But here we go. In addition, the right to jury trial in suits of common law preserved by the 7th Amendment is generally inapplicable in administrative proceedings. Okay. Hey, listen, that's a clear violation of your right to due process and face your accuser. Okay. Even above where it says the rules of evidence do not apply. That means they can just put anything willy-nilly in there. It can just be hearsay. It can be whatever. It doesn't follow the strict rules of evidence. Right.
No, and what Brad and I do is, when you get these administrative courts coming at you, our goal is to flip them into a judicial court. In other words, we're like Columbo. You get this mailing in the mail, and you say, oh, wait a minute, I don't understand here. It says, without service of process, the court has no personal jurisdiction. Oh, wait a minute, I'm looking at this thing the attorney wrote. He's got no personal knowledge of anything. He signed it. Nobody else signed it. It's not a complaint. This court doesn't have subject matter jurisdiction. So we're like, you go in there like, all you're doing is you're banging them over the head with the actual law. And they can try and railroad you all they want, but you stand your ground and say, wait a minute, administrative judge or not, he's bound by that state and federal constitution, whether he's an administrative hearing judge or he's a real judge that's in an administrative process. He's bound by that constitution. If you're invoking your rights, he can't say, well, we're going to ignore them in this administrative law process. Now he's going to have trouble when I sue his rear end in federal district court. Now he took an oath to uphold the Constitution, and when I was in there invoking my constitutional rights, he turned his head to benefit who? The municipality, who pays his paycheck, who greases his palms. That's why he's turning his head. He don't want to let me win, because that's more money for him and his buddies, the guys he goes to lunch with and plays golf with. So he don't want to let me win. So I'm probably going to get railroaded in any local municipal hearing thing I get. The best I can do down here is make something go away or make it go off into the ether, okay? I'm rarely ever going to get a judgment down in a state court. Probably, not unless I go to it, not unless you get out of the municipal court and go to like a state court.
The Superior Court. We've got
court,
they're called district courts here, right? The 19th JDC. That's a real court. It operates by the Louisiana Rules of Civil Procedure, and then I think it's the 6th or 7th that is the appellate court above it. But outside of that, you're really operating in administrative proceedings, and that's it. And so it's just like anything else. The IRS and everything else, those are administrative proceedings. You have to invoke your liberties, right? And when you invoke them properly, when the IRS starts sending you mail, all of a sudden at the end of the day, they don't want to mess with you anymore. They just go away. However, so let's finish this document up because I think people are starting to get the gist of what we're trying to explain here. Listen, guys, me and Alphonse aren't doing this because we learned this 2-3 years ago. This was an eye-opening couple weeks for us about a month ago. It was about a month ago, huh, Alphonse?
Administrative stuff. Well, yeah, I knew they were following process, and then when I read it, I went, "There it is."
There it is. You know it, but then you have to find what backs it up, right? And when you find what backs up your hypothesis, then you go, oh, "Okay, now I know where to hammer your asses." Right. And so administrative proceedings operate to the advantage not only of the litigants, but also of the courts. So it's a proprietary relationship, but also of the courts, which are thereby relieved of some matters on their dockets. Okay. However, the United States Supreme Court has repeatedly emphasized in regard to fundamental rights that judicial action possesses a degree of security superior to administrative action. Do y'all hear that? It is above administrative action, okay? So when your rights are deprived in these little quasi-judicial courts and you actually know, and now take it, granted, wildlife fisheries don't want anything to do with me. I called 3 agents. I did my investigation. I gave them my address, told them come on over. And then, of course, the Secretary of Wildlife Fisheries, after I talked to him and sent all my records requests, I'm sure it come down, don't go to that guy's house.
Don't they almost like, it's funny when you don't understand what they're doing to you, like people have them up on this pedestal, like they're afraid of them. Then once you understand what's going on and you start talking to them, don't they become like little kids? Like you're dealing with like little kids that got caught stealing. He's got his hand in a cookie jar and you're going, I think you're stealing cookies. Oh, not me.
No, not
they're
me.
like little kids, they don't know nothing anymore.
Yeah. Well, I asked the one agent I talked to, I said, hey man, have you ever read the Louisiana Constitution? And he goes, I don't think I have. And I said,
funny. Because for him to get that position, he had to take an oath to the Constitution.
I said, well, let me read a certain article from this. I said, do you know Article 27? I sure don't. I said, it states unequivocally, all men and women have the right, the freedom to hunt, fish, and trap all aquatic life in the state of Louisiana.
No, he worked for the wildlife that one section that is directly related to what he does, and he never read it.
Right. And so I went off on him a little bit. I did. I let a little anger out on him. I probably shouldn't have went as far as I did, but nonetheless, I did go about telling him how he's derelict in his duty, and he's totally ignorant of everything that he does. He needs to go check his life out. Like you need to go look in the mirror and see if you have a conscience, man. What you're doing is committing criminal acts against living men and women every day. That's your job. And you can't tell me that's your job description. But all right, so let's shift gears right here. I've
actually had them people say that to me when I said, hey, listen, you understand what you're doing is a crime. They said, I'm just doing my job.
That's
so
right.
Your job is to violate my rights and commit crimes against me. And that's what their mindset is. Yes.
Okay, so let's do this little workshop right here, guys. I did make this for people. This is a little deal I made. So let's go through here just a little bit. We're just not much, but I want to impound in y'all's mind the rules of statutory construction, and don't ever let anybody else flim-flam you or pull you away from this. The Louisiana Administrative Procedure Act. Louisiana Administrative Procedure Act is a law governing procedures for state administrative agencies to propose and issue regulations. All right, so anytime you see the word regulation, that's the regulation of commercial activity. Period. I don't give a crap. Man cannot be regulated as a mere thing. Okay, just can't. And provides for judicial review of agency adjudications and other final decisions in Louisiana. It can be found in Title 49. And then we go through the definitions, okay?
Agency adjudications.
That's right. That's
okay.
right.
These are these are, I would consider these parts of the executive branch, these agencies, okay? They relieve parts of the executive branch. They have no judicial power.
That's
okay?
right.
They can do internal things like you said, McDonald's with the brown uniform. They can't be judicial processes, hence the administrative law that they're pulling you in.
That's right. So we'll go to party. Party means each person or agency named or admitted as a party or properly seeking and entitled as of a right to be admitted as a party. So let's go see person. Means any individual, partnership, corporation, association, governmental subdivision, and it just goes on and on. So the individual must be a sole proprietorship. It can be nothing else. It cannot mean, and we'll go down here to the rule. Okay, this is from the Supreme Court plain meaning rule. It's Latin, nociquitur associus. When interpreting a statute, courts avoid ascribing to one word a meaning so broad that it is inconsistent with its accompanying words. The starting point in construing a statute is the language of the statute itself. The Supreme Court often recites the plain meaning rule, that if the language of the statute is plain and unambiguous, it must be applied according to its term. And this is the inclusio unis est exclusio altris, a rule of interpretation that states that including one excludes another. That's just the statement, no dogs allowed, under this rule would mean that panthers were allowed. That's just a fact. That's statutory construction. Okay. So then we just go to the Title 26, 77701. And I just did this for people to see how they match, okay? The term person shall be construed to mean and include, so we've excluded something right here, guys, okay? An individual, a trust, an estate, a partnership, an association, a company, or a corporation. So who owes taxes in the United States? Who owns income taxes, guys? Okay? This is a fact. This is a fact. You can't change how the rules of statutory construction go. And I don't know if I got anything else. Term United States when using the geographic.
And here's how simple that individual thing is. Imagine if they had, it's like putting man in a list with Mickey Mouse, Donald Duck, Daffy Duck. You can't have something that operates under one set of laws, basically the Constitution. Constitution doesn't grant you rights; it secures your rights. But you have access to that Constitution that administrative agencies do not. So you can't put us on a list with them and group us together. It doesn't work.
No, it doesn't. It doesn't. And I put two. I put one of your favorites, Newark Fire Insurance Company versus State Board of Tax Appeals in here. When a state exercises its sovereign power to create a private corporation, that corporation becomes a citizen and domiciled in the jurisdiction of its creator. There it must dwell. The dominion of the state over its creature is complete. So I went to another United States Supreme Court ruling too and pulled Oklahoma Natural Gas versus the state of Oklahoma. And so the reason why I pulled these two, because they have the least amount of negative treatments, by the way. Newark is a great case to cite for anybody. It only has, I think, 2 negative citations, and they were used out of context. It follows, therefore, that as the death of the natural person abates all pending litigation to which such person is a party, dissolution of a corporation at common law abates all litigation in which the corporation is appearing either as plaintiff or defendant. To allow actions to continue would be to continue the existence of the corporation pro hoc vice. But corporations exist for specific purpose and only by legislative act, so that if the life of the corporation is to continue, even only for litigating purposes, it is necessary that there should be some statutory authority for the prolongation. The matter is really not procedural or controlled by the rules of the court in which the litigation pens. It concerns the fundamental law of the corporation enacted by the state, which brought the corporation into being. He who creates controls. All right. It is the simple ideas that we must come to understand. Okay. Learning how to navigate, find which rules apply. And I promise you, I'll take this down now and I'll do it. We've gone an hour and 40 minutes now. I'll do the complaint another day. You're almost done with yours too, right?
Yeah, I'm ready to go. I'm just a couple of things that it's weird. They love to move stuff around. Okay, they'll repeal something, or they'll move something somewhere. So a lot of times you're working with one thing, and then you look at it and go, oh, look, repealed 2021. Oh, damn it. And you got to go back and find it. So it's just I'm just going through and doing the fine tooth comb thing right now. It's done. The pleading's done. I actually could submit it right now, but I want it to be as perfect as possible. Okay. So that when they get it, they look at it and they go, it just doesn't look like this came from a pro se. This looks like something an attorney put together. We can't answer this.
Well, Gary's 21st date is tomorrow, and we haven't got a reply.
Motion for default judgment.
That's what we're gonna be working on if the reply doesn't come in by tomorrow.
Yeah, and motion for default judgment. They had their days. They didn't respond.
It's wonderful. When you think about these things, they have to answer, okay? And we've already sent in records, requests for admissions, requests for production.
Did they give anything back? Did they give any of your discovery back?
They haven't even answered their original complaint. But go on the offensive, guys. Don't just sit around. You move the court. I'm writing a motion in limine to include the video evidence for the Mississippi Band of Choctaw Indians, where the guy tells me this is tribal law. That's all you need to know. Get out. Well, if he wasn't acting on color of law, I don't know what is color of law. And here's the beautiful thing about the Mississippi Band of Choctaw Indians. They don't have statutes. They're common law. So that executive order is just like their law. So
they're bylaws. They're corporate bylaws.
They're corporate bylaws. That's all it is. They've got a constitution and corporate bylaws. The ordinance was the statute. It's just as good as a statute. So
when you hear the term ordinances and resolutions, corporate bylaws. Okay, they're not laws. They're corporate bylaws.
Yeah, and look, each one of these movements through the court system, and every time you get more experience, you're going to get better at it. You're going to be more research. You're going to spend more time. Read. If any of you have a federal case out there, you need to go pick up the jury instructions from your circuit of appeals. What you're going to find inside those jury instructions is that particular circuit's all the controlling case law for Title 42, 1983, 85, 88, all those, 2000, public discrimination. They're going to have all the controlling case law in it. There's a plethora of free information out there to help you write this case. And once you take the jurisdictionary course, you apply the basics. You got elements that must be proven. Okay. Each element must be pled in order for you to actually state a cause of action which the court can grant relief. It's not complicated, but when you start talking with these law attorneys everywhere, like the attorney, one of the ideas is it's frivolous. It can't be frivolous because it's a constitutional right violation. It can't be frivolous because somebody somewhere violated my rights.
And what's good now with the Telegram groups, we're starting to get people that are actually filing federal suits. Like James the Patriot's got some, you got some, and mine are coming. And you're going to start to see a lot of them got them posted already. James got some of his suits posted. I don't know if you posted yours yet. Or I'm sure you will be posting it. But you'll have an outline there. You'll have an outline there of sort of how to put the case together. Yeah, the details are going to be different, but you'll have it's like building a house, basically. You got the foundation, you got the walls, you got the roof, and now we're just talking about what we're going to put in the house, the rooms, okay? So, but the structures are all going to be the same on these suits. The headers are going to be the same. The relief is going to be the same. It might be a different figure, but Now we're going to talk about what's inside the house, which is why you need to know the jurisdictionary course, because you'll read Brandon's suit or James the Patriot's suit or my suit, and you'll go, okay, this is similar, but mine's going to look like this, and I'm going to do this. So you're going to have an outline to follow for it. It's not like, gee, I have no idea how to write a suit. You're going to have some decent suits to look at and to follow.
I said that was an option at Tenempona. I never did anything. I quit filing returns. And there's a group of people out there that says, don't do that, whatever. And they vouch for the 1040 NR. I waited till I got my notice of deficiency. I showed everybody how I did mine. Okay. I got the notice of deficiency, and I spent 3 years writing letters back to 4 different heads of IRS, and every single one of them ended up sending me a copy back. They need more time to research your code. So if they ever bring a claim against me, I got the evidence to sue them. They could not validate their claim that I owed them money. So I mean, it's just simple. No, there's other ways to do it. I told people my way. I told people about the 1040 NR. I know the way that worked for me. That's it. I know which way it worked for me. All right. Anybody got any good comments, questions before we sign off here? Anybody? I can't believe we only had 150 people in here for an Alphonse and Brandon. I got to do a better job at marketing this stuff. I don't care, man.
No. It'll get out there. It'll get posted. It'll get seen.
Yeah, it'll get some traction.
We had we had the other guy in the groups. I think he might be popping in your group too. A guy named did you see Murder Hornet?
Yeah, I have seen Murder Hornet.
He filed a something. I forget the exact details, but he had to show his papers, his medical papers. They forced him or tried to force him to wear a mask. I think they tackled him. Well, he sued them. Okay. He got the judge to sign an order. They were supposed to have a mediation, okay? And the other party never showed up for the mediation. So he filed for sanctions against the other party for 10 grand. Guess what happened? The judge signed it.
Yeah.
Judge signed it. Guess what? He got his money for the sanctions. He got his 10 grand. And his initial offer to settle with him was 50 grand. They doubled that to 100 grand. Oh. Now, he didn't want to take that. He wants more money. Whatever. That's up to him. Whatever he wants, decide he wants. But he didn't do this through his birth certificate. He didn't do this through his secret trust. He did it by filing a lawsuit in federal district court saying, who the hell are you people to make medical determinations for me, to tell me I got to wear a mask, and that when I didn't wear the mask, you physically assaulted me. Okay. Yeah. You committed crimes against me. And at first they laughed at him. And then when he filed his paperwork, they no longer laughed. Okay. When the lawsuit got filed, they no longer laugh. You know.
Well, no, it's like so the shots went out when we gave one last good faith effort to settle out of court. You know, Gary and I, the shots went out. Why are they suing us? It's not for masks. It has nothing to me. It has not. Yeah, the mask is one of the tools, but it has to do with the people, the Gestapo. Stopping you seized my movement of freedom. That's what you did.
That's what we were talking about the other day. It's funny. It's an art of pleading. It's weird. Like, say I got busted for carrying a gun without a permit. Okay, which we know is nonsense. All right, I have a right to carry a gun. If I sued him in federal district court, I don't go argue that I got a right to carry a gun. I don't argue that. Oh, here's my argument. Listen, I was walking down the street, okay, and this guy accosted me. This guy, a municipal corporation employee, known as a police officer, assaulted and battered me for some reason. I don't know why he did that.
Yeah.
I don't say anything about the gun. He said this. I don't understand it. He assaulted and battered me. It's up to him to turn around and argue, well, Mr. Faggiolo was carrying a gun without a permit. Here's his problem. We talked about pecking order. I already have the constitutional right to have the gun. I don't need to argue the right. It's a given, okay? It's up to him to explain how the statute that he was following of me having to have a permit somehow superseded my right. That statute that was created under that Constitution, it's up to him to argue how his statute superseded my right to have the gun. So it's an art and pleading where don't go arguing rights you already have. argue what they've done to violate you, basically, and let them come back and argue why they did it. Hey, listen, we tackled Brandon because the governor said you had to have a mask. Well, good luck trying to plead that or answer a pleading like that, because there are no laws like that. And like what Brandon was talking, we're talking about the something like concealed carry permit. Well, these are administrative laws. This is not constitutional law. These are administrative laws, okay? They can't control whether you have a gun or not. That's a protected right in the Second Amendment. In Pennsylvania, guess what? You can open carry. No permit, okay? But if you conceal it, you need a permit. Does that make any sense to anybody?
No.
Okay, either have a gun or you don't, right? And we know that the Second Amendment says what? It says there's no...
Shall not. Shall not.
What's the exact words? Shall not be infringed.
Shall not
be infringed. Now, it doesn't say, hey, listen, you can carry a gun, except you can't conceal it. You're going to need a permit for that. This is administrative law that basically they're trying to impose upon people. These are administrative laws. So when you argue this stuff, you do not argue your right to have the right, okay? You argue, hey, these, like the tax thing, here's the argument. I've looked at Title 72, Title 53, the Local Tax Enabling Act, Title 71, the Reform Act. I can't find anywhere in any statute where it states an agency of the state or an employee of the state can take property from the people. Can't find it anywhere.
You're not going to find it anywhere.
I'm not arguing about, like Brandon said, it's not a tax suit. My suit's really not a tax suit, okay? My suit is, I don't know what these people are talking about. They're saying, they're taking money saying I'm a taxpayer, but I'm reading the definitions of taxpayer in Pennsylvania, and a taxpayer is defined as a legal entity registered with the state conducting business in the state. This isn't me. So I'm not going to argue I'm not a taxpayer. I will argue that, I will state that, but the underlying principle of the argument is, hey, listen, here's what a taxpayer does. That's not me.
That's
okay?
Right.
Now, I'm not going to argue taxes are unconstitutional. Taxes are not unconstitutional, okay? Taxes can be imposed upon what, Brandon? Corporations, okay? They're not illegal in that matter.
You have to have some form of revenue. You do, okay? But we went from a free people from the 30s to the 50s with the propaganda. Everybody moved to the suburbs and all that crap, and we gave up our freedom of property and everything else to go live the corporate nightmare. And guess where we are now? We're inside that corporate nightmare.
Yeah, it's sort of like what I said, like boiling the frog. You put it on cold, and it'll never know he's being boiled. Well, that's what they do with the property tax stuff. When property taxes first started, I think when my parents moved from Philadelphia to Ridley Park, I think their taxes were like a couple $100, $200-$300, nothing, right? Now we're up to about $7,000. Well, when does that stop? Because we all know the income levels are not meeting the housing prices. Okay,
that's right.
In other words, the housing prices. You go look at a housing scale within the last 6 months, it's like a hockey stick. They've doubled. Okay, I've looked at a house in Florida that were on the water for $250,000, $275,000 8 months ago. Now they're like $500,000-$600,000. Now the house is going up, okay, but people's incomes haven't doubled in the last 6 or 7 months. So it's going to, listen, if you don't get a hold of this stuff and learn how to do this stuff, it's just a matter of time before they're going to tax you out of your house. You're going to work all your life, live in your house, you're going to retire, and then your taxes are just going to go so high, your property taxes, they're literally going to tax you out of your own home because you're not going to be able to afford to live there, okay? And that's sort of what got Steve into doing this stuff. Friends of his lived on the lake, and the mother was moving. The father had passed away, and the mother was moving, and he said, well, why would you be moving? Oh, you got everything paid off. And she said, I can't afford the taxes. He said, well, that doesn't make any sense. And that's where all of us are, okay? If you don't get these people, like Steve said, away from you and away from your property, they will literally take everything you have by taxing it away from you. That's right. Why we do this, to wake people up, to teach them how to fight this.
Yeah, and it's very simple. The truth is that it's taken inch by inch until it's a mile, right? And look, listen, a lady who bought her house for 60, 70,000 back in 1970 is now paying $9,000 a year, and she's 68, 70 years old. That's criminal. That's criminal, and it's insanity to me that now you look at the report for the justification. I got one report for the justification as from a records request on why the taxes were, and it states on top schools. Okay. The second line is the county maintained and operated, and the third line is hospitals, and it was $9,000 tax. So you are officially paying for the services that are destroying your entire society.
You're funding your own destruction.
You're funding your own destruction. That's why they're putting up these hospitals on every corner. When I was a kid, and I know you know this too, there was one hospital in the area, right? Maybe two in a major city, maybe three. But dude, there's a hospital on every corner, everywhere you go now.
Yeah, absolutely. And look at these police vehicles they have. They look like something out of Batman. The cops got like 2 computers in there, and they got all these they got Humvees that are militarized, and they don't need that stuff. They were never supposed to have that stuff. Okay, they don't need that stuff. And so what they're doing is they're looting tax money from the people because the people don't know any better, and they're using it to oppress the people. That money they're taking from you, they're creating these municipal courts, putting these judges in there, paying them all this money to bring you in there and violate your rights. Okay, you're funding your own destruction, is what you're doing.
That's the truth. All right, buddy. Well, I thank you for coming on again. Hey, listen, what I do, I'll call you sometime in the next few days. I've got a few things coming up, especially if they default tomorrow. I'll probably call you for a little advice on that. But if you do get yours sent in and the summons done, we might share them together. I'm going to post it I told the guys on Telegram that I was going to post it. So Gary, I'll post the complaint tomorrow on Telegram. It's a very well-written complaint, guys. We worked on it for 7 months. Here's the crazy thing, and Alphonse attests to this. Today I read it and I find something I could change.
Dude, it's amazing. It's amazing. You just like there's a goblin somewhere that comes in and goes, he's sleeping. You go change that. I mean,
yeah,
you always find something.
You can't help it. But eventually I told Gary 3 weeks ago, whatever, I said, listen, I got to stop looking at it.
Listen, I'm a recording engineer. Okay? I used to mix songs for a living, okay, and record. Listen, mixing, here's what mixing is. You'll mix, and you get the song sounding really good, You could literally mix for 2 days, 3 days, 4 days, okay? You have to hit a point and say, you know what? This is good enough, okay? Because it becomes paralysis by analysis, okay?
Yeah.
You'll just never, you got to get it to a certain point, like Steve said. When I got the property tax suit, and I was asking him certain questions about the suit. And he said, listen, hey, listen, he said, don't get all hung up on the other stuff. He goes, listen, that whole suit comes down to this. There's no return, okay? So there can be no assessment, and there can be no tax. All the other stuff, don't get hung up in all that. In other words, it's great. You can mention it, just build your case, but you could get away with just those 3 things, okay? And that sort of got my head back into focusing, like, don't worry about, oh my God, I missed this, or I put this in wrong. It's going to destroy my entire suit. No. You got to get to a certain point and just go like this. Okay, I'm done,
The rules for pro se's, and I want to tell people this right now that's still in here. So there was a point where Brandon was going to go through and make a completely common law pleading. I read a 1,000-page book on how to plead a common law pleading, okay, to deal with the Mississippi Band of Choctaw Indians. And let me tell y'all something, folks. People that say they want to go back to the common law are insane. And how to plead in the common law, because it was much more technical than what we have today. So now I want to cite the case law for pro se litigants, right? Pro se litigants are given much more leeway in the district courts, trial courts, and appellate courts for not knowing the intricacies. But here's the beautiful thing. A pro se litigant that's wielding the rules of evidence and rules of procedure are better than 90% of the lawyers out there.
Listen,
No.
when I first sent my very first discovery request out, after you read the jurisdictionary course, you do this stuff, and the first time you're doing it, you're like a little kid. Oh, let me try this. Let me see how it works. So I sent admissions to the sewer authority attorney. Now, listen, you know what admissions are. Here's how you answer admissions, people. Yes, no, or accepted, denied, or not enough information.
Right.
Accepted, denied, or not enough information. That's it. They're your three answers. Those, you don't elaborate, okay? So I send these admissions questions out. They should be accepted, denied, or not enough information to respond. I get paragraphs back for each discovery, for each admission. Instead of just saying accepted or denied, he wrote me paragraphs. I looked at that and I went, he broke every rule of what I was taught. You ever give anyone more information than they need? You never want to do that, right? Your opponent, why would you give me paragraphs when all you can say is denied or accepted? When I seen that, I went, wow, here's an experienced attorney with probably a $250,000 education. He don't know the basics of discovery, of just saying accepted, denied, or not enough information. He like a fun, that's like saying, hey, listen, when you're playing baseball and you're holding the bat, keep your hands together. Don't hold them like this. It's like a basic fundamental thing. And really, he didn't know it or didn't use it. And I went, wow.
It's amazing because what you'll find out is that most of them are so used to being in the administrative courts that they really don't know the rules of evidence and the rules of procedure.
It makes them lazy and fat is what it does.
Right.
They get used to the judge doing that. And then when you or I come along and we bang them with stuff they haven't seen before from a pro se, dude, they're not prepared. They're not practiced. They don't read it and they don't understand it.
That's right. They really don't. And it's fun. Look, guys, I promise you, if it's going to turn from a mindset of worry, anxiety, and fear into one of power, love, and a sound mind, and you're walking around with a baseball bat and you're like, homie, don't play that. That's what you're doing with these people.
When we left the court yesterday, my buddy Carmen was with me. Carmen, big biker, like the big guy, I think the lawyer was intimidated because Carmen's right behind me. And I said, listen, like you said, I couldn't contain it anymore. I kept it together in court. But when I got outside with him, it just came out. And I said some choice words to him, called him some things, and told him, you mess with my property, I hope you had good insurance. I said, here's what's going to happen to you. I'm going to bar grieve your ass back to the Stone Age. That's going to affect your insurance. I'm going to file state criminal complaints against you. And then I'm going to sue your ass in a Title 42, 1983 suit. And you're going to learn just who the hell I am. Okay? You want to involve yourself in property you have no rights to? You're going down. Dude, he never opened his mouth. He's like scurried away like the rat he was. Okay? He knows right away. Now, listen, I'm not proud of myself for that. Okay? That's just one of those things. It came out. But he knows one thing now. I'm not afraid of him a little bit. I not only have no fear of him, I got no respect for him at all. I'm not worried about fighting him. That's a worry to your opponent. Okay? Bullies like to beat people up that they can control and beat up. They don't like somebody that steps up and says, hey, you want to get it on? Let me show you what I'm going to do to you. And that's what you do with this stuff. It's empowering.
And when you exhibit the mindset that you can't take anything from me in this reality, if you think I'm ever going to go lay down and just put a belly up, it's not going to happen, Halls. It's not going to happen any way, any shape, or any form. And that mindset exudes out. Okay, because they're not operating on those same principles. I could promise you that.
No, listen, my property has a lot more value to me than to him. Okay, in other words, I will fight you to the death for it. Yeah. You think he's going to fight me to the death for it? And if you think when I go after him and I now put his property in jeopardy, something he's never seen before, where he's over there toying with other people's properties by doing all these illegal things. He's been getting away with this for years, maybe decades. He's been getting away with it. Now I'm coming after him. I'm going to put at risk everything he's ever worked for and everything he's ever owned. Because now I'm going to sue him not only his official capacity, in his individual capacity, which means I can go after everything he owns, basically. So if I get a judgment against him for $1 million, he better have $1 million sitting in an account somewhere burning a hole in his pocket, or it's going to hurt him some way. If he ain't got the million, well, guess what? Now we got to go get his house. We got to go sell his house to make up the money he owes me or his car or whatever. When he sees you coming at him with that ferocity, these attorneys will back away from you, okay? So it's like anything. It's why we tell you not to get attorneys. No one's ever going to fight your cause harder than you, all right? No one's ever going to they're not going to put the energy into what you're going to do. And the people that Brandon and I have seen that have been totally successful, ton of people that have been successful, they've done it themselves, okay? They took the stuff we taught them and they executed it, but they did it themselves. And once you get that little success, I don't care how little it is, if it's getting your school to drop the mask mandates, okay? Don't care how little the win is. Once you get that, it becomes addicting. It feeds your knowledge, your need for knowledge, because you're going to go, wow, look what I just did. And one of the things I laugh about, and I tease Steve about, and I think Steve was teasing me, and he said, no, he wasn't. I told him, I said, Steve, I said, for 30 years since I lived here, when the sewer authority would send you a bill, Brandon, on the back, it was all these threats. If you didn't pay this bill, we're going to do this, we're going to do this. It was like, I'm talking threatening, okay? For 30 years they did that. When I started submitting record requests back in 2019, I attacked that right away. Hey, sure looks like mail fraud to me, extortion. You people are posting threats on the back if I don't pay you. Guess what's not on the back of those bills anymore? It's white paper. Right. They took it off. That was because of me, okay? Nobody else was fighting this. That was me. Evidently, somebody in their legal department or their lawyer said, hey, we better get that off the back of that bill. This guy could actually come after us for this because it sure looks like extortion. Now, Steve goes, no, I never did that. I said, no, you just got like $50 million in judgments. I'll trade you. I'll give you the blank paper for the 50 million judgments, you know. But the point is, listen, once you get that little success, you'll be stunned at how your mind will open. You'll start believing this stuff. And it's almost like the knowledge gate opens up and things will just start to make sense and work for you. And then you'll have another success. And then that'll build. And you'll see it. It'll just, they keep coming. They keep coming. And the more they come, the more it's like anything. You always want to get better at something, especially when you're starting to have success. You want to get better at it. And you'll start to really dig into the law stuff. Listen, me and Brandon don't want to do this stuff. I got many more things I'd rather do with my time than to read case law and read American jurisprudence and write paperwork all day, because that's what I do. But I can't say it's not empowering, okay?
Yes.
I don't fear people. I don't fear my municipalities. I don't fear the county. I don't fear any of these people. First of all, I fear one thing, my creator. When I die, how am I going to look in his eyes, okay? That's what I care about. I don't care about these people. These people can't hurt me. And now I know they can't hurt me because I know how to put legal roadblocks up against them. Every time they move, I will keep legally roadblocking them. And then when I file this property tax suit, I will become the most unpopular person in Delaware County, okay? That I won't be able to get a traffic ticket in Delaware County in a couple weeks. Because once this suit hits, it'll spread like wildfire around to the different townships and the boroughs of what's going on. Your name, listen, you will be infamous in your county, okay? Your name will start to spread around, and they will say, leave that guy alone, okay? Because they got 99.9% of the other monkeys that they can go generate revenue from. And if you're that one monkey that takes them in and sues them, they are going to leave you alone. So one of the things we can empower you with is, hey, listen, you actually don't have to run around suing people all the time. That's not what this is about. If you file that one lawsuit and it's a humdinger, okay, and you get that settlement, they're going to learn who you are real quick. And guess what? You're probably not going to have any problems with your local county and your local town. And the cops are probably going to leave you alone because they are going to know your name. Trust me.
Well, that's going to go back into what we're finding out now, that there's an international database that we're finding out where people are really classified as sovereign citizens. Right now, right. They use it against union.
We're
right?
Probably in there. We're probably
We're probably in there. But I guarantee you, that once you win a couple of these lawsuits, what's going to happen? You're going to go in that database also as he's sovereign.
Yeah. Wait, and the best, I gotta find the best clip I've ever seen is there's a clip of two cops. They pulled over this SUV and they're on the side of the road, and they got the body cameras running. Okay, and the cops are talking to each other, and you don't see them, but you hear them talking. And the one's trying to pull up the computer information and run the guy's license plate, and the one guy says, "Oh F," okay, "Oh shit, oh F," and the other guy goes, "What?" He goes, "That's the guy. That's him. That's the guy." Well, here's what happened. Evidently, the police, the police station and the local town there, they were running an illegal rodeo. Okay? They were putting animals. They're rodeo, like they're doing all kinds of heinous stuffed animals. They had this little rodeo thing going together. The police station and the town. This guy in the SUV sued them. Sued the city. Sued the cops. He sued the town. He beat them. He beat him in federal district court under Title 42, 1983, okay? He whacked him. So these two are talking. Oh, my God, that's the guy. And you hear the one guy say, "Oh, shit, we're going to get sued." And you hear the other guy go, "This guy's the real deal." Now, his reputation preceded him. As soon as they pulled his name up, he filed that one lawsuit and won. They knew who he was. And guess what? I didn't see the conclusion of that traffic stop, but I'm going to bet they probably sent him on his way. Okay? They didn't do anything to him. And this is what you want to do. And here's what you also got to realize. By you doing this, you're going to be one of the very few in your county or your town that are doing this. That's another thing that's going to make you stand out. It's not like there's 200 people around me that are doing this in my county. I'm probably one of, maybe I'm the only one I know of, okay? Because I don't hear this from anybody else doing this stuff in my county, in my township. So if you do this stuff, they are going to know who you are real quick, okay? Your reputation will precede you, which is a good thing because that's where your freedom comes from. It's not about birth certificates or filing statuses. It's about being left alone because people fear you on what you can do, okay? That's where your freedom comes from. Guys like Steve Emerson. Steve never has anybody suing him. The co-guy never comes near his house, okay? He got nobody bothering him. Because why? Because Steve will thump them, and they know it. That's what we're trying to help you people to be, and that's what we're trying to be. We want to be that big gorilla, too, that walks around and goes, pound, pound, pound,
Well, yeah, and look, it's really, so let's, and for any of y'all that haven't been paying attention, if you want to take your time at the end of this, you can actually get the whole complaint. I shared it while Alphonse was talking. I'll keep going. You can pause it. You got the whole complaint right here. Everywhere for clause, request for relief. I did the whole thing. But the truth is that I envision a day where I'm just left alone. Okay. And that's right. That's what I'm working for. That's what I'm working towards. Right. I have the common law right from God to just simply be left the hell alone. Right. I don't invade anybody else's property. I don't invade anybody else's privacy. I know as a reasonable man, my duties towards each and every one around me, I don't breach that duty. Now you're going to stop breaching yours.
I seen this great cartoon the other day. It was the one guy, the cartoon says, "I just want to be left alone," the guy says. And they got like the cops together. Oh, got another one of them sovereign citizens. I just want to be left alone. That's what it all comes down to.
That's right. That's right. And look, I do enjoy this because what this, so law and spirituality, these ideas are intertwined. Okay. They really are. And so we're at a point in society where we're as dumb as a box of rocks. Folks, this can be defeated though, like everything else. It can always be defeated. You do it with righteousness and justice.
Explain what it does for your spirit and the empowerment.
That's
when
right.
You take a bully, like an attorney that acts like a bully, and you get in his face and you make him back away from you, okay? And we do it all the time, okay? I got an attorney fired. I told you the sewer authority. He got fired, okay? That's empowering because, listen, they're not used to this. They're not used to you and me getting in their face and going, "Hey, guess what? You just made a major mistake. You have no idea of the can of worms you just opened up." And then when you start working through this process, like Brandon and I talk about, where you file bar grievances, judicial complaints, state criminal complaints, federal criminal complaints, and file that civil lawsuit for a huge amount of damages, they will come to they may hate you. Okay, I'm sure I'm hated, but they will respect you. Hey, listen, I might hate somebody, but there are people I respect. Okay,
that's right.
They can hurt you. Okay, and that's what you want to be. I don't care. Like I said, I don't care if I'm loved. Right? I don't care if I'm loved. You know,
doesn't bother me.
Right? Doesn't matter to me. I just want to be respected.
What anybody thinks about me does not dissuade me. I live in my own little world, folks. I don't allow any outside penetration into this kingdom right here. I'm completely oblivious to what people say about me.
Right.
Hey, Alphonse, bless you, brother. Thank you for coming to spend the time with us.
Always
again.
good. Always good.
We're gonna do it again soon.
Sure.
I think this one with the administrative law and these. I knew we had to do it. From the time we did it last time, I knew there was going to be something else that exploded our knowledge too. And guys, do y'all understand this? When we get it, we share it. When the epiphany happens for us and we tie it in, we instantly share it.
We just saved you 10, 20 years of work, basically.
Yes.
I mean, there's people that are still doing this stuff. That there's attorneys working right now that don't understand that there's an administrative law process and a judicial process. You just have, like I said, we've handed it to you. We've given you a head start. Just take from this video and this foundation and go read the documents Brandon's copied on administrative law and the stuff I put up on administrative law. You have such a head start above everybody right now. Now you know what you're dealing with traffic court and all this other crap that's going on. You got the basics.
Yep. It's a blessing. Thank you so much, Alphonse. Guys, love each and every one of you, and we're out of here.